Hello everyone. Today we are going to talk about the rights and duties of the bank. We all use banks regularly. We open accounts, we withdraw money, we deposit money, but do you know what rights your bank has and what are your duties as a customer? This is what we are going to learn today. Let's get started. First, what exactly is a banker customer relationship? When you open an account with a bank, you are entering into a legal agreement. This relationship is governed by contract law, the Banking Regulations Act, and the Negotiable Instruments Act. Now, here's the interesting part. The bank doesn't just act in one capacity. Sometimes the bank is your debtor, meaning they owe you money when you deposit. Sometimes they are your creditor, meaning you owe them money when you take a loan. Sometimes they are your agent, meaning they work on your behalf. So the same relationship can have different meanings in different situations. The bank's role changes depending on what transaction is happening. Primary duties of banker. Now let's talk about what the bank must do. What are their duties? First, the bank must honor your checks. When you have money in your account and you write a check, the bank has to pay it. The, they cannot refuse. Second, the bank must keep your account information confidential. Your financial details are private and the bank cannot share them. Third, the bank must keep accurate records of your account. Your account statement must be correct. The bank also has duties to honor guarantees they give, honor letters of credit, provide safe custody for valuables, and not convert excess credit into overdraft without permission. These are the core duties that make the banking system trustworthy. Next one is duty to honor checks. The duty to honor check is one of the most critical obligations of a bank. For the bank to honor a check, certain conditions must be met. First, you must have sufficient funds in your account. If you have 5,000 rupees and write a check for 10,000, the bank will not honor it. They will return it marking as insufficient funds. Second, the funds must be properly applicable to the check. If you have a fixed deposit of 1 lakh rupees, you cannot use that money to write a check. The bank keeps that locked for a specified period. Third, the check must be presented properly. It must be within 3 months of the date, not post-dated and not damaged or altered. Now, if the bank wrongfully refuses to honor your check when you have sufficient funds, they must pay you damages. For business people, a wrongful rejection damages their reputation and credit standing. Courts recognize this and award substantial damages. For individuals who are not traders, damages are typically nominal unless special loss is proven. Next is duty to maintain secrecy. The bank has a duty to keep your account information confidential. They know how much money you have, where it comes from, where you spend it. All this is private information. But this duty is not absolute. There are situations where the bank can disclose information. If tax authorities ask for information, the bank must provide it. If police ask, the bank has to answer. The government has the power to demand information from banks. Also, if you give permission, the bank can disclose information to others. And if the bank needs to protect its own interests, they can disclose information, like when recovering a loan they have given you. The key is disclosure should be limited to necessary information and made to authorized persons. The duty of secrecy continues even after your account is closed. Next, duty to honor guarantees and letter of credits. Bank guarantees and letters of credit are important in business transactions. Bank guarantee is a promise by the bank to pay it if their customer fails to meet obligations. A letter of credit ensures payment is made when goods are shipped according to the agreement. Banks cannot escape these obligations just because the underlying transaction has difficulties. Once the bank issues a guarantee or letter of credit, they must honor it. The bank's reputation depends on this. These instruments are essential for building confidence in commercial transactions, especially in international trade. Failure to honor these amounts to a deficiency in service. Next, bank's rights of general lien. Now let's talk about the bank's rights. The first is general lien. Lien means the right to hold on to something until a debt is paid. If you owe the bank money and you have given valuables or securities to the bank can hold on to those things until you pay back your debt. For example, you owe 50,000 rupees and you have given gold ornaments for safekeeping. The bank can retain them until you pay. But there are limits. The bank cannot use lien for everything you have deposited. If you deposited something specifically for safe custody, the bank cannot use it as lien. Or if you give shares with instructions to sell at a certain price, the bank cannot use them for lien. If you deposited something for a specific purpose, the bank cannot repurpose it for their own protection. The right is recognized in Section 171 of the Indian Contract Act. Next is bank's right of set-off. Set-off allows the bank to adjust mutual claims. Say you have a saving account with 1 lakh rupees balance and a loan where you owe 2 lakh rupees. The bank can take the 1 lakh and put it towards your loan. Now you owe only 1 lakh. That's set off. The bank combines accounts and settles them against each other, but there are conditions. The accounts must be in the same name and same capacity. You cannot mix a personal account with a partnership account. Why? Because partnership money is not all yours. It belongs to the partnership. The bank cannot take it for your personal debt. The debts must be actual, not future or conditional. The amount must be clear. In certain situations, if you become bankrupt, if you die, or if there is a garnishee order, the bank has automatic right to set off. This provides immediate protection. Banker's right of appropriation. Appropriation decides which debt your payment goes towards. Imagine you have borrowed multiple times at different rates. You borrowed 1 lakh at 8% interest. You also borrowed 50,000 at 10% interest. Then you deposit 50,000. Should this go to the first loan or the second? Here's the rule. You have the first say. If you tell the bank this goes towards my 10% loan, the bank must follow that. If you don't give instructions, the bank can decide. They usually follow the rule of Clayton's case. This means the oldest debt gets paid first. So always tell the bank which loan you want your payment applied to. Don't assume they will know. Bankers' other rights. The bank has other important rights. First, the bank can charge for services, account maintenance, issuing checkbooks, ATM cards. These have costs. The bank charges you. This is normal. If you cause loss to the bank through carelessness or fraud, the bank can recover that loss. If you forge signature and the bank pays because of that, you have to pay back. Third, the bank can refuse service or close your account if you misuse it. If you use your account for illegal activities, the bank can terminate it. The bank has the right to recover dues through court proceedings. If you owe money and are not paying, the bank can use. These rights protect the bank's interests. The bank is a business and needs to protect itself. Next comes the obligations of customer. Now, what are your duties as a customer? First, be careful with checks. Write amounts clearly in words and figures. Don't leave gaps or spaces. Someone could alter it. Write everything close together. Sign your checks the same way you signed when opening the account. If you normally write Priya but suddenly sign P. Sharma, the bank might not honor it. Second, keep your checkbook safe. Lock it. Don't leave it lying around. If someone steals it and forges your signature, you are responsible. Third, don't write checks without sufficient funds. If your check bounces, it's embarrassing and also illegal. Fourth, pay bank checks on time. Fifth, if you lose your checkbook or ATM card, tell the bank immediately. The faster you report, the safer your account. Sixth, if you see errors in your account statement, inform the bank. Don't ignore mistakes. Follow these and your relationship with the bank will be smooth. Important court decisions. Several court cases have shaped banking law in India. Tornian versus National Provincial Bank established that banks have a duty to keep customer information confidential, but the court also said there are situations where banks can disclose information, like to government or tax authorities, so secrecy is not absolute. Joe Kimson versus Swiss Bank Corporation established that a deposit creates a debtor creditor relationship. When you deposit money, the bank becomes your debtor. Hedley Byrne versus Heller and Partners established that if the bank gives advice, they have a duty of care. They cannot give careless advice. Indian Bank Aluminum versus Industries Limited is an Indian case. A company deposited money and asked the bank to remit it on a certain date. The bank delayed, currency devalued in the meantime. The company had to pay more. The court said the bank was negligent and must compensate. These cases show that courts taking banking seriously and protect both bank and customer interests. Thank you for watching.